All rise. The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Seated. We are here today in the matter of 4 separate cases. The case of Mary Catherine Wallace versus Kristen Wildensee and Mary Wallace is hereby submitted without oral argument. And our first case today, actually there'll be 3 other oral arguments today, and the first one will be Planned Parenthood of the Heartland, Inc. versus Kim Reynolds, ex-rel State of Iowa. Looks like the parties are ready. It's my understanding, Mr. Schandevel, are you going to argue for the appellant?
Yes, Your Honor.
Thank you. You may begin.
Thank you, Your Honor, and may it please the court. Chris Schandevel with Alliance Defending Freedom, appearing pro hoc vice today on behalf of Governor Kim Reynolds and the Iowa Board of Medicine. For close to 100 years, this court has repeatedly reaffirmed that courts have the authority to vacate or modify their own injunctions based on a substantial change in the law. The district court tried to distinguish each of those cases based on differences that did not make a difference in any of those cases, and based on distinctions that do not make a difference here. As this court plainly held in Bear, the court which rendered an injunction may modify or vacate the injunction if over time there has been a substantial change in the facts or the law. The district court erred by concluding otherwise, and accepting Planned Parenthood's arguments in defense of that decision would require rewriting this court's case law on that question. Instead of rewriting the court's case law, the court should simply apply its case law and reach the merits. On the merits, in our opening brief, we've laid out 2 possible paths that this court could take to reach the result that we're advocating for. The first path we've laid out in part 2 of our opening brief. The second path we have laid out in part 3 of our opening brief. Under that,
Before you get going here, I want to make sure that I understand the red brief is correct, that there were 2 concessions made on behalf of the governor and the state. One concession is that no Iowa rule of civil procedure permits the motion to dissolve. Okay, and the second one is that the district court's conclusion, you are not challenging the district court's conclusion that the ban would fail under the undue burden standard.
That conclusion, assuming the undue burden test that this court would apply if it were to adopt that test were the exact same as the test that the U.S. Supreme Court applied in Casey. I mean, that test
last year.
Honor, the plurality opinion did not adopt that test. The plurality opinion was very careful to say we're not deciding what should be the test going forward because the state hasn't asked us to decide what the test should be going forward. We're going to simply ask the parties on remand to take evidence under the undue burden test based on the pluralities thinking that the test applied in PPH 1 remained the governing standard, but the plurality specifically invited further litigation on that question. So the state was perfectly prepared on remand to further litigate that question, but my friends on the other side voluntarily dismissed that case, so we didn't get the opportunity to litigate the standard there. So what we did on behalf of the governor and the Board of Medicine, we filed a motion to dissolve the injunction issued in 2019. In this case, we asked the district court to allow the parties to further litigate that question exactly as the plurality in PPH 4 said the parties could do. And the district court concluded that it could not reach that question because this court's language in PPH 4 that the standard applied in PPH 1 remained the governing test for now. The district court thought that that prevented the court from deciding that question in the first instance, and instead that question should be left for this court on appeal.
The plurality opinion explicitly said the parties are free to litigate the correct standard. So if the standard is at issue, what is your argument for rational basis versus undue burden?
To the question of what the standard should be under Iowa law, it's a very straightforward analysis, and the answer is that the test has to be rational basis analysis. As this court has said in cases like King and Sanchez, the test under Iowa law, King, Sanchez, and Searing, the test under Iowa law is a two-stage analysis. The first stage is determining the nature of the substantive due process right that's being alleged, whether or not it's fundamental. This court answered that question in PPH 4 just last year and said the alleged right is not fundamental. The second part of that analysis, if the right is fundamental, strict scrutiny applies. If the right is not fundamental, rational basis review applies. So we're on the merits, we're simply asking this court to complete that second part of the two-stage analysis. The only option available to the court is rational basis analysis.
Paths you started to outline before we interrupted.
Path is the one that we advocated for in the district court, and so that would mean holding that the district court erred by not further litigating that question of what standards should apply. We think that question was an open question for the district court to litigate. We think, especially post Dobbs, the PPH 1 majority opinion's reliance on the alleged concession by the state there that the state right is coextensive with the federal right, and therefore the court applied undue burden analysis. Once there is no undue burden test under the federal Constitution, any weight to be given to that concession would actually lead to the opposite conclusion, that now that rational basis review is applied under the federal Constitution, rational basis review has to be the test under the state Constitution. But we're not asking the court to rely on that alleged concession. We're just saying under that first path, the question was an open question the district court could have resolved. The court erred by not resolving it.
You say that there's no ground in between strict scrutiny, fundamental right on the one hand, and rational basis on the other. Wasn't there in this country sort of an intermediate standard under, at least as to the federal right, at least between Casey and Dobbs?
Intermediate standard, but that standard was based on the premise that the abortion right was a fundamental right. So in Your Honor's majority opinion just last year in PPH 4, Your Honor walked through some of the other substantive due process contexts, including a right to procreate, a right to family creation, et cetera, and said in those contexts, we've done something that looks more like an intermediate type of scrutiny, but in each of those cases, in reading the majority opinion there, each of those cases that intermediate level of scrutiny was premised on the existence of a fundamental right. So yes, when there's a fundamental right at stake, the court has applied some different type of analysis, but there is no fundamental right here, and when there is no fundamental right at stake, the test has to be rational basis.
You about what I wrote, but I will. I think every time I said we're not recognizing anymore what we said in Planned Parenthood 2, that it's a fundamental right subject to strict scrutiny. I think I always tied those two phrases together. It was the strict scrutiny part that I thought we were overruling in Planned Parenthood 4.
We read the court to be doing both, and I don't want to argue about what Your Honor wrote either in PPH 4, but we read the court to be doing both. The test and the analysis that this court walked through is the same analysis that the U.S. Supreme Court applies in determining whether or not a fundamental right exists. Is it deeply rooted in the nation's history and tradition, or in the text of the Constitution? The answer to that question this court reached in PPH 4 was clearly no. And so if there's not a fundamental right, the only option available is the rational basis test. Now, again, we're not contending that the PPH 4 plurality decided that rational basis review is the test. We just read the court's language saying there is no fundamental right subjecting the analysis to strict scrutiny to mean that the plurality was simply not going to decide what the test was.
To sort of the first area that you were arguing, you're correct. There are a fair number of Iowa cases where if there is an intervening change in the law that means that the injunction is no longer supportable, there is a legal basis to go back and revisit the injunction. It strikes me that you're asking for more than that. You're asking for a change in the law and then to apply that change in the law to vacate the injunction. Am I missing something?
So This gets me back to the point that I began to make earlier about the two possible paths the court could take. So under the first path, we are arguing that there was a substantial change in the law based on this court's decision in PPH4 and the U.S. Supreme Court's decision in Dobbs that justify dissolving the injunction below. Under the second path, though, and this is the path that we lay out in part 3 of our analysis. Yes, Your Honor.
First path. So you said dissolving the injunction, and then what?
Path is that this court would hold that the district court erred by not allowing that further litigation. The district court erred by not finding that rational basis review is the only test with any basis in Iowa law when there is no fundamental right, and therefore the district court erred by not dissolving the injunction. And so this court would remand the case back to the district court with instructions to dissolve that injunction based on a substantial change in the law so that my clients can begin enforcing the fetal heartbeat law going forward.
Remand for further development of the record. So even if we conclude rational basis applies, why wouldn't we remand for development of the record?
Like this court's decision in King, when we're doing rational basis analysis, the state is not required to put on any form of proof to support its rational basis as long as there is a rational basis that's conceivable. We actually did put on evidence in the district court as to the level of fetal development that occurs by 7, 8, or 9 weeks.
Body of case law that indicates that the hearing on a motion to dissolve an injunction should be separate and distinct from a second hearing on the merits of the legal issue. So it's kind of a two-step process, and I understand that some of the legal issues may be the same, but it seems like procedurally the better method, if you're right about the injunction, is to remand it. Why wouldn't we do that?
Aware of case law showing that it's a two-step process and that there has to be a remand. What I am familiar with is this court's decision in Searing. So in Searing, the district court applied a strict scrutiny analysis to the alleged fundamental right of a sex offender to live within a certain number of feet of a school and held that statute was unconstitutional under a strict scrutiny analysis. That case came before this court on appeal, and this court held that analysis by the district court was incorrect. There was no fundamental right to live within a certain number of feet of a school. Therefore, strict scrutiny was not the test. Rational basis review was the correct test. And instead of remanding that case back to the district court to apply rational basis review in the first instance, this court went on to apply rational basis review in State versus Searing and to conclude that the law was constitutional. So we're just asking this court to follow the same path that it followed in Searing. Once the court concludes that, yes, Your Honor.
Have you complete your second path?
So my second path, Your Honor, is part 3 of our opening brief, and that's what the U.S. Supreme Court did in Agostini. So Agostini was an Establishment Clause case, and the injunction that was at issue in that case was actually an injunction that had been issued 12 years earlier on remand from the U.S. Supreme Court's decision in Aguilar. And so 12 years after that injunction, that permanent injunction was entered, the parties who were bound by it, so the Board of the Education for the City of New York and the parents there, filed a petition to modify or vacate that injunction based on what the parties perceived as a substantial change in the U.S. Supreme Court's Establishment Clause jurisprudence. And what the district court said there was, I don't have any authority to overrule the U.S. Supreme Court's decisions. I have to leave that to the U.S. Supreme Court to decide in the first instance. And what the U.S. Supreme Court said in Agostini was actually not that the district court erred, but that the district court was correct to wait for the U.S. Supreme Court to overrule its own case law in the first instance. The U.S. Supreme Court Agostini went on to overrule Aguilar and then went on to hold that because that district court opinion was premised on a case law from that court that was no longer good law, that opinion, that decision by the district court had to be reversed, and the court remanded with instructions to dissolve that injunction. So that's the second path. So this court could hold, assuming without deciding that the district court was correct not to decide in the first instance whether or not rational basis review is the correct test going forward, and assuming the district court was correct to leave that question for this court can still hold in the first instance rational basis review review is the correct test under Iowa law. Iowa's fetal heartbeat law easily satisfies that test, and therefore the district court's injunction cannot be allowed to stand, and remand with instructions to dissolve that injunction. I went ahead and reread Agostini last night. It's almost eerie how similar the procedural posture is in that case to the procedural posture here.
As I read the red brief, they distinguish that case by saying that that was decided under Federal Rule 60, and that our civil rule is different, 1.1012. And so if you could respond to that argument.
We point out on page 47 of our opening brief, a point that my friends on the other side don't respond to. It's long been established, and this is quoting Wright and Miller on this point, that Rule 60b-5 is, quote, little more than a codification of the universally recognized principle that a court has continuing power to modify or vacate a final decree. So it's the same power, the same inherent authority that we're invoking in this case under Iowa law, under cases like Wilcox and Iowa Electric and Spiker, which postdates the rules, obviously. That's the same authority that was being applied in Agostini under Rule 60b. The only difference is it's been codified there. It hasn't been codified under the rules here, but it's the same authority. Yes, Your Honor.
I think relies on restatement second of judgment, section 73, and that uses the language may, implies that the court has discretion, that it's a discretionary consideration. You weigh a lot of factors. Why shouldn't we take into account, say, the fact that this particular law was adopted several years ago? There's been substantial turnover in the legislature. When the prior law was adopted, it was clear that it would be unconstitutional as soon as it was adopted. Why not give the legislature an opportunity to go back and pass whatever law they now think is appropriate in this area? And then Planned Parenthood might challenge that law, and we would have a fully developed record to decide a case.
The legislature will have the opportunity to decide, whether or not this law ought to be amended based on the will of the people that they represent. If this court dissolves the injunction, allows the state to begin enforcing it. But the reality is the law was validly enacted when it was enacted in 2018. I realize then that Roe and Casey were still on the books, but we've concluded now that those cases, the U.S. Supreme Court has concluded those cases were an incorrect interpretation of the federal Constitution.
That some of the legislators in 2018 might have voted differently if they knew the law was going to go into effect at that time?
Appropriate for this court to be speculating as to what the legislators might have thought or not thought. The court could just as easily speculate that the legislators believed that the law was constitutional when they passed the law based on their own understanding of the Iowa state constitution and the federal constitution. And what we know now is that they were correct, that the fetal heartbeat law is constitutional because there is no fundamental right at stake, and because under rational basis review, the law clearly survives. And if I could just make one point on the rational basis underlying.
Speculate, but didn't you just ask us to speculate or tell us to speculate what they might do as far as an amendment?
So my point is that the legislature, no, Your Honor, the point is simply that the legislature has the authority to change the law if the legislature thinks that a change needs to be made. Our position is that it's not the role of the courts to be deciding what the legislature might have done previously or what the legislature might do in the future. When we're dealing with a rational basis analysis, the only question is, did the legislature have a rational, conceivable basis for the law when they passed it? Here they clearly did. That was the holding in Dobbs. Under a rational basis analysis, the state's interest in protecting and preserving fetal life is a legitimate interest. Actually, in PPH2, yes, Your Honor.
The case, June Medical Services versus Phillips, federal district court case post-Dobbs.
I believe that I am. No, Your Honor.
Bring it up, and I can give you the citation, and I'll ask counsel about this. So this is a post-Dobbs case to vacate a permanent injunction. And the court holds that it would be an abuse of discretion to continue to enforce an injunction when the underlying law is changed. I don't know the status of that case, if it's up on appeal to the Fifth Circuit. I just wondered if you were familiar with it.
case, but that ruling is consistent with the federal cases that we've cited in our brief, like the American Horse decision written by then Judge Ginsburg on the D.C. Circuit Court of Appeals, where she wrote that when there has been a change in the underlying law, when that law has been superseded, it is an abuse of discretion to refuse to lift that injunction going forward. So we think that's perfectly consistent with the position that we're taking here, that the district court abused its discretion in not lifting the injunction. But even if this court, again, under Path 2 in Agostini, yes, Your Honor.
Back to this speculation versus speculation, because isn't it true that under our case law that we have a presumption that statutes are valid, and isn't that rooted in our respect for the legislature and our assumption that they act with the understanding that what they're doing is constitutional, as opposed to some idea that they would be acting with the assumption that they're acting unconstitutionally?
Exactly correct, Your Honor. The legislature is bound by the same oath to the Constitution that this court is bound by. So if there's going to be any assumption or speculation, it ought to be that the legislature was following its oath to enact laws that are consistent with the Iowa Constitution and the federal Constitution. And again, we know now today that even though this court and the U.S. Supreme Court had previously misinterpreted the federal Constitution and the Iowa Constitution, that what the legislature did in 2018 in enacting the fetal heartbeat law, it's perfectly consistent with both constitutions. Because there is no fundamental right to abortion. Therefore, under Searing and Sanchez and King, the test is rational basis review. And the legislature clearly has a legitimate, and this court in PPH2 said a compelling interest in protecting and preserving fetal life, especially in this case at a point in fetal development when the unborn child's heart has begun beating, when brain waves are detectable, when she can already move, when she already has sensory receptors, when her facial features, her chin, her jaw, her cheeks have already begun to form, and at a point in pregnancy when, absent abortion, the vast majority of unborn children will survive until birth. That is a rational basis for the law the legislature enacted here. We think it would be inequitable to continue to prevent my clients from enforcing that law based on a prior case of this court that was wrongly decided. For all these reasons, we're asking the court to reverse the judgment below. Thank you, Your Honors.
It's my understanding Mr. Eam will argue. Is that correct? That's correct, Your Honor. Thank you.
Thank you, Madam Chief Justice, and may it please the court. Peter Eam on behalf of Appellees. The state is asking this court to disregard the Iowa Constitution and its own procedural rules to revive a statute that was declared void over 4 years ago and that has been enjoined ever since. As an initial matter, this appeal is not procedurally proper because there was no new final order to appeal. And on the merits, the state's arguments fail for 3 reasons. First, the ban is void because it was unconstitutional when it was passed. Second, Iowa procedures do not permit the state's motion. And third, there was no change in law that would justify vacating the injunction. Starting with the motion to dismiss, the district court's December order is not a final judgment under Rule 6103.
And explain to me the argument that the law was void. What do you mean by that exactly?
Under the plain text of Article 12, Section 1 of the Iowa Constitution, any statute that is inconsistent with the Iowa Constitution shall be void. Those are the words of the Constitution. And in the words of this court in Security Savings Bank, that means that the law is void as though it never existed. That is consistent with the intent of the framers of the Constitution, who at the 1857 convention.
Saying that it's removed from the code?
Your Honor, it is null and void. It's as though it never existed, and it's
Saying that this is removed from the code.
a technical matter. I don't believe it would be removed from the code, but it would be without effect.
In any circumstance could rely on the statute, correct?
I want to make clear.
During the pandemic, we issued a supervisory order that told the statute of limitations. Judge Huppert held that provision of the supervisory order was unconstitutional and void. So are you saying that that supervisory order is void no litigant in the state of Iowa can rely on it unless we reissue the order?
Your Honor, I have two responses to that. First, that is not our position. Certainly, the litigants in that case could have appealed the district court's declaration of voidness to this court.
Order from a district court holding one of our orders unconstitutional. Your position is that makes it legally void. That's the facts of this case, as if it didn't exist. So no party can rely on that. Is that what you're saying?
In a future case, if someone made the argument that under Article 12 that ruling was void, then this court could pass on that and decide whether that ruling was correct to begin with. And in this case, I think it's beyond dispute that on...
You're not saying we have the authority to pass on the constitutionality of this statute. You're saying it doesn't exist. So I'm asking you, what's the status of our supervisory order if your theory of law is correct?
Constitutional by a district court and is not in effect, then that is the status. And then if a future party decides to appeal that decision and bring it to this court, then this court can pass on that initial decision. I think that you have to look at both the time that the order went into effect and the time of the ruling and now. And I think that that case is...
In this case, you have a district court order holding a statute unconstitutional. The law has changed. Now a party is seeking us to make a legal determination on the constitutionality of the statute. It's the exact same fact pattern.
This case, because in 2018, there's no question that this law was unconstitutional under the Iowa Constitution, under this court's holdings. And I'm not...
The McCulloch case in 1909, because wasn't that true when they enacted that law, that it was already unconstitutional under federal precedent?
There, we have to look at the plain text of Article 12. Article 12 says that any law inconsistent with the Iowa Constitution shall be void. McCullum and the O'Neill case that followed it in 1910 both dealt with laws that were unconstitutional under the U.S. Constitution. Article 12 doesn't have anything to do with that.
Another, in the Godfrey case, which a different case, Justice Apple wrote the majority opinion, and he had this theory that Article 12, Sections 1, et cetera, was mostly transitional. It was a way to transition into the new Constitution of 1857. And I disagreed with him at the time, but now I think there might be something to that. If you read Section 1, it says, the Constitution shall be supreme law of the state. Any law inconsistent therewith shall be void. General Assembly shall pass all laws necessary to carry this Constitution into effect. And then the next section says, all laws now in force and not inconsistent shall remain in force. Maybe all 1 and 2 we're dealing with was that transitional period where we were adopting in Iowa a new Constitution, and what it's meant to say is the stuff that went before, if it's inconsistent, it's off the books. If it's consistent, it's still on the books, and the legislature gets to adopt new laws to implement it. What's wrong with that reading?
I have two responses to that. First is that it appears that the framers of the Constitution copied Article 12, Section 1 verbatim from the Rhode Island Constitution, which had been passed about a decade and a half before. And it was the consistent holding of the Rhode Island Supreme Court from the 19th century to the present that that provision of their Constitution means that any law that is unconstitutional is void. Second, Your Honor, Security Savings Bank.
Out in the dissent in Godfrey, or a related point. Go ahead.
Second, the Security Savings Bank was decided in the 1920s. That's after McCullum, after O'Neill. And in that case, this court explained that the meaning of Article 12, Section 1 was that any law inconsistent with the Constitution shall be void. Now, I want to point out and make very clear that we're not saying that the state is without recourse to any remedy here. The state could certainly go and repass a law. And if that happened, then we would challenge it. It would be up on appeal. And all of these voidness and procedural issues would not be live.
Distinguish this statement in O'Neill. It says, this is what we held. It is, of course, well settled that a statute which has been held unconstitutional, either in toto or as applied, is valid and enforceable without reenactment when the supposed constitutional objection has been removed or has been found not to exist. And I understand your argument about voidness, but it's void in the particular case so long as the constitutional infirmity remains. I mean, I don't know how O'Neill could be clearer, and how do you distinguish it?
Context of O'Neill, it would be our position that it refers to the federal constitution and that the court was not implicitly overruling Article 12, Section 1 in that case. But, Your Honor, even if the court concludes that the law is not void, Your Honor, as an initial matter, the appeal is not properly before the court because there was no new final judgment under Rule 6103. Now, I want to explain why that rule makes sense in this case, and I think to understand that, it's helpful to zoom out a little bit and look at what the state's asking for. So below, the state moved to dissolve based on a purported change in the law. So the state argued that the law had changed. Now on appeal, they've shifted their position, and they all but admit that they're asking for that the law hasn't changed, and they're asking for the court to change the law. And it's that shift that's improper. And rule.
Isn't that what happened in Searing? Isn't that what happened in the Agostini case? I mean, isn't that exactly what the court did? It took that case and then decided the underlying issue?
Your Honor, Agostini, as Your Honor pointed out, deals with the federal rules of civil procedure, and certainly while that procedure may be proper, I don't believe that the Iowa procedures permit that. Also, my understanding is that this is the first time that they're arguing that that Agostini permits a movement to shift positions, saying that the law has changed below, and then trying to get the law to change. And Your Honor, Searing, I don't believe involved the same procedural issues. And so, Your Honor, because of that procedural issue, it's our position that the proper procedure would be for the state for this court to dismiss the appeal, or in the alternative, to construe the appeal as a petition for writ of certiorari. And in paragraph 8 of their resistance to our motion to dismiss, the state actually concedes that it cannot obtain the relief that it seeks on a certiorari proceeding.
I think what you're saying, if I'm hearing you, is they don't have an automatic, mandatory. This isn't a mandatory appeal. We're now in discretion land, so it's up to our court whether we want to exercise the discretion. And that rule kind of makes sense, doesn't it? Because otherwise, people could go in and try and dissolve injunctions all the time and take appeals up to our court, and we'd be hearing cases all the time.
That's exactly right, Your Honor. I think that if this court were to allow the state to proceed on the merits, that would open the floodgates of litigation to a litigant who is bound by an injunction.
Before, right? In Helmkamp in 1977, the court went back in and changed an injunction based on a nuisance, right? And in that case, it said that it was based on a change in facts. This is the ready mix plant in Carroll. And the court said that based on a change of facts, it would undo that injunction. Here we have a change in law, but why can't we undo it here?
Responses, Your Honor. First, on the motion to dismiss, I believe in Helmkamp, the district court actually did grant the motion to modify the injunction. And if the district court in this case had modified the injunction, then that new order would be a new final judgment because it would be a new disposition of the rights of the parties. But when a district court denies a motion to vacate an injunction or modify an injunction, then that new order denying the modification motion is not itself a new final judgment. So that's our position as to the motion to dismiss on Helmkamp. Now, on Helmkamp, as to our procedural arguments, Your Honor, I think that there is there's really a value in limiting the degree to which district courts can depart from the holdings of this court. So certainly this court has held that changes in fact do justify modifications of injunctions, but I don't believe that this court has squarely held that a change in the law justifies a motion to modify.
Between the two, why is that material?
Your Honor, it's material for two reasons. First of all, from the plain text of the rules, so from Rule 1.10.12, it allows for modification of judgments based on newly discovered facts or evidence, and that, I think, is more analogous to a change in facts than a change in the law. And second, historically, changes in law have not been allowed. So,
Saying that, I mean, I think there's 600 years of common law history in every jurisdiction in America that allows for this, including our own cases that explicitly say that. So what is your basis for saying that's not been allowed?
Your Honor, as we set out in our motion, in courts of equity, historically, going back to the 17th century, motions to modify injunctions would have been understood as bills of review. And there are 19th century cases from Iowa that lay out that changes in law are not proper bases for bills of review. And
2006 case, Spiker, where it explicitly says the rule 1.103 governs petitions to vacate or modify, but that does not deprive the court of its common law power to modify judgments granting continuing relief. So we don't have to go to the 16th or 17th century. We can go to this century, and we've said that repeatedly.
through what the court did in Spiker. So the court initially did look in footnote 2 at the Iowa Rules of Civil Procedure, and that is where we should begin. The state is asking this court to find some kind of hidden inherent authority that's found nowhere in the rules. It says that this court has been following a substantial change in law standard, but that standard also is not found anywhere in the rules. And Your Honor, in Spiker,
Hidden. We say it's a common law power inherent in the courts to modify judgments. That's what we wrote in Spiker.
this court went through a careful analysis of whether there was jurisdiction to modify an injunction. It did analyze the federal rules. It analyzed System Federation, which was a U.S. Supreme Court case decided under Rule 60B. What it did not do was just wholesale adopt the federal standard. If that's what it was doing, then Spiker would have been a much shorter case. It wouldn't.
To change in facts, it's okay to upend an injunction, but if it's a change in law, it isn't?
Your Honor, but even if this court concludes that a change in law does justify modification, sure.
Adhering to the text of the rule under your argument, what provision of the rule says a change in facts post-judgment allows modification of an injunction?
The argument is more that that we would look at the text of the rules.
We have to adhere to the text of the rule. So what provision in the rule allows for modification of a permanent injunction more than 1 year after the fact based on change in facts?
If I said that it has to be in the text of the rules, I misspoke. I meant that it would have to be in the text of the rules or a judicially recognized exception. But ultimately, Your Honors, even if this court concludes that modification is a basis for, a change in law is a basis for modification, the law in this case simply has not changed. And even if the district court has inherent authority to modify injunctions, that is a discretionary authority.
In PPH2, that case relied on strict scrutiny, right? And we said in PPH4 that decision was wrong. Isn't that a change in law? I mean, that was the whole basis for this injunction in 2019.
Change in law. In PPH4, this court held that the right to abortion is not a fundamental right under the Iowa Constitution, subject to strict scrutiny. But the PPH4 decision left in place the undue burden standard. And under undue burden, the state has conceded that, that this ban does not pass constitutional muster.
Argument for why we should, going forward, continue to apply some form of heightened scrutiny, something in between strict scrutiny and rational basis.
Contexts involving constitutional rights, commercial speech comes to mind, voting rights. This court has applied intermediate scrutiny. And in the PPH2 dissent and the PPH4 plurality opinion, this court laid out that there's a reason that we have the undue burden standard because there are substantive due process rights at stake, and that's weighed against any interest that the state has in protecting potential life. But the undue burden standard does protect pregnant people's rights to privacy, to bodily autonomy, to liberty. These are the rights that are protected. And the undue burden standard accounts for that. And Your Honor, because of the strange procedural posture of the case, because this case was decided under a different standard, and then the next time the issues were live was a motion to dissolve, there are claims in this case that haven't even been litigated at all. So we didn't raise our Article 1, Section 1 claim, for example.
Abortions after 15 weeks survive an undue burden challenge.
Question is not before the court, and certainly if this court adopted an undue burden standard, then ultimately it would be up to the court to decide exactly what that undue burden standard means. I think that we would argue that it would not, but that is not the question here. The ban in this case involves a ban at 6 weeks that record in the evidence shows would outlaw 98% of abortions in the state of Iowa.
That there might be other challenges that PPH would raise to the statute. Let's assume that we conclude the district court erred or abused its discretion on the procedural issue, on whether it had the power to actually dissolve an injunction. Does that mean then that we should remand this for further proceedings as opposed to deciding the issue as a matter of law in this court?
Your Honor, I think that would be the proper procedure, as this court did in PPH 4. That's because there is this Article 1, Section 1 claim that's still live. It's inalienable rights claim. And I know that courts in other states, for example, have decided that their inalienable rights provisions protect the right to abortion. And there are also still facts that are in dispute. The state itself points out a factual dispute in footnote 1 of its brief. And because of those disputes, the proper procedure, if this court reaches that question, and if this court ultimately decides that the court abused its discretion, would be to remand. Your Honor, I want to point out one final thing, which is that
Follow up to that. If PPH has different constitutional arguments that it's raising, can we even decide the standard of review or the appropriate substantive standard without knowing the constitutional provisions at issue? So would it be remand with instruction like we did in the prior case, saying the standard should be subject to further litigation and development in the district court, or should we decide a standard here?
Your Honor, I believe that the proper procedure would be to let the district court decide that in the first instance, because these Article 1, Section 1 claims have not been aired at all. Article 1, Section 1 was amended in 1998 to include women's rights. It says all men and women shall, and Your Honor, I see that I am out of time. May I conclude? Yes. Thank you. So Article 1, Section 1 guarantees the rights to enjoy life and liberty and to pursue and obtain safety and happiness to all men and women in Iowa, and that incorporates the understanding of women's rights in 1998. So for all of those reasons, Your Honor, we would ask this court to dismiss the appeal. In the alternative, construe the appeal as a motion for writ of certiorari and deny the petition. Or if this court denies our motion to dismiss, to affirm the ruling of the district court. Thank you.
Thank you, Your Honor. A few quick points in rebuttal. I want to pick up with the voidness issue and go to something my friend on the other side said when he first took the podium, which was that because the district court declared void the fetal heartbeat law 4 years ago, it is therefore forever void and forever to be deemed unconstitutional. We just don't think that that's the way that the decisions of lower courts or even decisions of this court work. It's not up to the courts to declare a law constitutional or unconstitutional. It's the Constitution itself that determines whether or not the law is or is not constitutional. So yes, the district court declared that the district court's interpretation of the state constitution was that the fetal heartbeat law was unconstitutional in 2019, but we now know that there is no fundamental right to abortion under either the Iowa state or the federal constitution. So our reading of Article 12, Section 1 in the state constitution is similar to the reading in Godfrey that was earlier discussed. That provision simply states a truism that when there is a conflict between the Iowa Constitution and a statute passed by the legislature, the Iowa Constitution necessarily trumps a statute passed by the legislature. However, that truism does not speak to the question that's before the court, which is what happens when a later decision by a court overrules a prior determination, a prior interpretation of the state constitution, so that the alleged constitutional defect is determined to have never existed or to no longer exist. This court addressed that question in McCollum and O'Neill and clearly held that there is no need to reenact the underlying.
On how far back we can go. I mean, just another example. In 1980, our court held in a case called Beer Camp that the guest statute was unconstitutional, split in authority other jurisdictions, U.S. Supreme Court holding to the contrary. We applied a rational basis test. That was probably wrong. If today we overrule Beer Camp, does that put the guest statute back into effect, or with the passage of time and change of circumstances, should the current legislature decide what to put onto the books?
The same position that the parties were in here, that if there is a substantial change, or if there's a change in the law, the interpretation of a statute or the Constitution by this court, then the parties enjoined, based on a prior interpretation that is determined to be erroneous, have the ability to come into court where that injunction was first issued, file a motion to modify or dissolve the injunction, just like we did here.
Injunction?
That's the context that we're in here. I mean, without an injunction, then the parties are free to enforce it the entire time. But when there is an injunction, the limiting principle is the power of a lower court to lift or modify an injunction has to be coextensive with the power of the court to enforce that injunction.
Consider other changes in the law since 2018, and in fact, some fairly recent changes, given the legal uncertainty over the medication abortions with conflicting rulings, challenging the FDA's approval authority. Are those reasons to say, let's go back to let the legislature go back to the drawing board and enact a law reflecting the current views of Iowans and take into consideration recent rulings?
Legislature has the ability to enact a law that is consistent with the current views of Iowans. If the legislature believes that the fetal heartbeat law passed just 4 years ago is inconsistent with that, the legislature can call a session and amend that statute. So I've never seen a case where the court has considered. Yes, Your Honor.
Do you know of a case or of any authority that holds the judicial branch can prevent another branch of government from enforcing the law because the composition of the legislature has changed, and we think that the people should just have to reenact the same law to confirm that they meant what they said?
Two cases that we believe are wrongly decided that held that. So the Sister Song case out of the Georgia trial court, which has been stayed pending appeal by the Georgia Supreme Court. The very old Jefferson case from, I believe, the Louisiana Supreme Court. But as their own authorities, the Triner and Sperling article pointed out, those cases were wrongly and poorly.
Let me play name a case with you. Also, I'll do what Justice McDonald's just done. Can you give me a case in Iowa where our court has, in the course of reviewing a previously adopted injunction that's final, that's not on appeal, that based on has gone ahead and both changed the law and then used the change in the law to vacate the injunction, as opposed to a situation where there's an intervening change in the law that that clearly makes the injunction insupportable, like Spiker. Have we ever done the two-step that I was talking about earlier?
Aware of an Iowa case that takes that second path that we've laid out in our briefing. So our position is that Agostini is the authority that this court could follow for that second path. The court could assume that the district court was correct to wait for this court to decide the question of what standard to apply, but still reverse the district court's decision and remand with instructions to dissolve that injunction. There is plenty of authority for the first path that we've laid out, which is that if the court agrees that there was a substantial change in the law based on PPH4 and Dobbs, because the question of what the standard is became an open question, and under binding Iowa case law, the only option available if there's no fundamental right is rational basis review, then necessarily this law survives that review. And Your Honor, we spoke earlier about the majority opinion in PPH4, and I did go back and look at the portion of that opinion that I was referring to when Your Honor does discuss, this is at Penn site 739, the majority opinion says, previously, even when we deemed a right related to parenting fundamental and implicit in the concept of ordered liberty for purposes of substantive due process, we analyzed whether the government restriction directly and substantially intruded upon it. So still dependent on there being an underlying fundamental right. That paragraph uses the word fundamental 5 separate times. So anytime the court has done something short of strict scrutiny but still above rational basis review, there's still a fundamental right that's at issue. Whereas here there is no fundamental right at issue, the only option available is the rational basis test.
On the last point that opposing counsel was making, and that is that we should remand to hear the arguments under Article 1, Section 1. What is your response to that argument?
This court's majority opinion in PPH4, I believe it's footnote 23, but don't quote me on that, actually addressed that issue and said that the analysis under that provision of the Constitution is a rational basis test. So that's the substantive response, is that it's the same test that we're asking the court to apply under the alleged substantive due process right. So the analysis works the same way. The court could do that analysis here. The second response would be that the only question before the court is whether there's been a substantial change in the law that undercuts the basis upon which the lower court issued its injunction. So that injunction was not based on any other provisions of the state constitution. It was based on the substantive due process clause and equal protection.
Counsel in favor of a remand. Essentially, we put the parties kind of in a status quo ante position, and we can say the law has changed. There's no legal basis for enjoining a statute or the enforcement of a statute, but the parties should be able to start over and litigate, kind of this two-step process.
Responses, Your Honor. The first is that we don't think that that is the case. The second response I'll touch on first, though, is that if the court does conclude that the important thing would be that while the case is litigated on remand, the injunction needs to be lifted because it would be operating as essentially a temporary injunction, and we cited the Hertco decision from this court in our briefing below, that where there is a temporary injunction, if there's a dispute in the law, an injunction should not be allowed to take effect when those issues are being litigated. So at the very least, the court should lift the injunction while the case is litigated on remand or order the district court to do the same. On the merits of your question, though, whether the court should remand for further litigation, I can't do any better than Justice Waterman's concurring opinion in King, where he wrote that a remand, this is quote, a remand for a costly trial to prove allegations that, if true, provide no grounds for judicial relief would be unwarranted. And we think remanding the case here for further analysis under rational basis review would be unwarranted. And as the U.S. Supreme Court pointed out in Agostini, it would be inequitable to wait for a subsequent appeal to come back before this court. And Agostini
Is a mandatory vaccination law, is that subject to rational basis review?
Vaccination law, I think what would come into the court's consideration there is the common law right to decline or reject medical treatment. So the question would have to be whether there is a fundamental right to reject that medical treatment that's within the scope of that common law interest. So it would be a completely separate analysis, and depending on whether the court says it does fall within the scope of that fundamental right, then the court would apply strict scrutiny. If it does not fall within the scope of that right, the court would apply rational basis review. But just to finish my point from a moment ago about Agostini. In Agostini, the U.S. Supreme Court explicitly rejected the argument that the court should remand and wait for a better vehicle or wait for the case to come back before that court. And what the court held there, that case was dealing with a school policy that was getting school funding to disadvantaged kids that attended parochial schools. And the court said it would be inequitable to force these disadvantaged kids to wait to get the necessary funding, to get the resources they need for a better vehicle to come before the court. That's the same here. It would be inequitable for this court to wait for a different vehicle and to prevent the court from enforcing its validly enacted law to protect unborn children from the point of a fetal heartbeat being detected. Thank you, Your Honor. For all these reasons, we're asking the court to reverse the decision below and to remand the case with instructions to dissolve that injunction and to allow the state to begin enforcing its validly enacted law. Thank you, Your Honors.
Planned Parenthood versus Kim Reynolds et al. Is hereby submitted. The court will take a brief recess between cases.